Hello everyone, welcome to the channel AMC Lawsuits and Justice, Project Popcorn, The Scheme. Today is February 1st, 2026, 3:47 p.m. Eastern Time. There was a shareholder, I don't know if he wants me to identify him, but he's a great shareholder where I speak to him offline, brought to my attention that there was a lawsuit filed out in the Southern District of New York. It's before Judge Jennifer Rochen. The case number is 25 Civ 09042. It's with regards to Securities Commodities Exchange, and the docket is titled Simons versus AMC Entertainment. And when you go to the parties, you'll see the plaintiff's name is Robert Simons, and who represents him? Frank Iacono and his law firm, and then we have his contact info. If for those who were following the Delaware lawsuits, this name should ring a bell, and we'll get back to that in a couple of minutes. So just remember the name Frank Iacono. Basically, this attorney is representing Robert Simons, and they're suing AMC. Now, let's go over the docket. It scrolls, we're going to scroll bottom up, or we'll start off with docket entry number 1, which is always usually the complaint. I'm not going to open up this document because the complaint was amended. So they filed and they paid the $405. And let's continue. They requested issuance of the summons, and then other things were filed. How important is it? Not that important. Let's go to docket entry number 7. Somewhere I forgot. Hold on. Is it 7 or 8? Basically, the judge ordered the attorney to disseminate or publish and give us shareholders notice that a lawsuit was filed, because this is moving forward as a class action on behalf of APE, if you owned APE shares or APE units. And let's continue. Now, mind you, this was December 3rd. So he didn't comply with the initial order. Then she gave him a second chance. I don't think he complied yet, but he did issue, which is key, the summons, and he effectuated service on AMC. And if you look at docket entry number 11, you will see that the summons was returned, executed. And now the instructions from the court is, they did the math. I think they're given 21 days to file a response to the lawsuit, whether it's an answer or asking for more time to respond, or they file a motion to dismiss. And then it concludes, it says that Gail McClinton was received service, and that's it. So the key date is February 17th. Let's see what happens. On or before that date, AMC has to respond. So let's go back. Who is Frank Anthony Iacono? Now, you could see on this website, Justia Lawyers, you could see this attorney went to Harvard. His law firm's out, I think, in Long Island. And there's the map. Here's the address, and here's the phone number. I've actually tried to reach out to him many times since this amazing shareholder gave me the heads up. He never returned my call. So I might file a letter with the court saying this attorney is supposed to be representing us and is not returning our calls or communicating with us. All right, so now let's go to this docket entry, which is number 6. So it's right here. This is where he amended the complaint. So the initial complaint was docket entry number 1. Now this is the operative complaint. So it supersedes this one. This one is not relevant. This is what the court is going to focus on. And how did I get this document? The attorney we're trying to retain, I gave her notice, or I relayed the message to her once that amazing shareholder gave me the heads up. And she downloaded this document and then emailed it to me. So we could go over it. So as you can see, it says document number 6. It was filed on October 31st, 2025. It's 14 pages long, and you can see the docket entry. The last 3 letters is the name of the judge, and that's the docket number. So you can see it's filed in the Southern District of New York. You can see who the plaintiff is, and it's a class action. They're demanding for a jury trial, and AMC is the lone defendant. So let's go over a couple of things. We'll read it. Once again, it's 14 pages long. This is just the opening. What's the nature of the action? This is a federal securities class action brought on behalf of all persons and entities who purchased or otherwise acquired APE during the class period. So what was the class period? And we'll get into that now. And were damaged thereby. Among the class are those who held apes immediately prior to the August 25th, 2023 conversion and were thereby excluded from receiving the special dividend issued to common shareholders on August 28th, 2023. So the class period begins from August 18th, 2022, the date of AMC's false and misleading public assurance regarding economic equivalence, and ends on November 1st, 2023, when the truth was first publicly revealed. I will actually publish this, save it in the cloud, and anybody wants to download it could gain access to it. So let's continue. Averment number 3. On August 18th, 2022, AMC filed a frequently asked question FAQ document with the United States Securities and Exchange Commission that made unqualified statements to investors that each ape was designed to have the same economic value as a share of Class A common stock and designed to have the same voting rights as a share of common stock. AMC further stated that because of this design in theory, the common stock and AMC preferred equity unit should have similar market value, and the impact of the AMC preferred equity unit dividend should be similar to a 2-for-1 stock split. These statements were materially false and misleading because the rights of ape holders were in fact constrained by the Certificate of Designation (COD) for AMC's preferred stock, which contained a highly technical loophole allowing AMC to exclude ape holders from distribution occurring after conversion to common stock. This loophole was subtle, non-obvious, and undisclosed in the FAQ or other public investor communication. Anyway, the harm to ape holders accrued on August 28, 2023, when after converting the apes to AMC common stock, the company delivered a special dividend of common stock exclusively to the prior holders of common stock. The special dividend, pursuant to a settlement of litigation brought on behalf of common shareholders. Anyway, the fraudulent nature of AMC's earlier statements was finally revealed when AMC, in a November 1st, 2023 motion to dismiss a breach of contract action brought by ape holders, openly argued that ape holders had no rights to participate in the special dividend. AMC's legal argument constituted a plain admission that apes were not economically equivalent to common shares, and therefore a plain admission of AMC's fraud. Then we go over jurisdiction and why it should be filed in the Southern District, how they're establishing jurisdiction, why it's in the Southern District, what's the federal law that allows them to establish jurisdiction, which is Section 27 of the Exchange Act, Section 15 U.S. Code Section 78 AA, or Title 28 U.S. Code Section 1391. And then we go over the parties, and then it goes over the allegations. I don't want to go into great detail in this video, but maybe the next video will go over the factual background. I will, well, like I said before, I will save it in the cloud and then provide a hyperlink. But this is the lawsuit. If you owned ape shares and you're interested, once again, here's the number to Frank. Place a call and see if he takes your call. Now, let's bring up Frank Anthony Iacono again. Why is he important? So, if in Delaware, on March 1st, on 2023, it hit the docket at 5:48 p.m. out in Chancery Court in Delaware, and this gentleman, Frank Iacono, filed an emergency motion to intervene. Now comes the proposed intervener, Frank Iacono, and moves on an emergency basis to intervene in the above captioned action as follows. Now this is his preliminary statement. He admits he's a licensed attorney in New York. And this is the background. He tells that he basically was against the conversion reverse split, but his ownership was only of ape. He said he began purchasing shares of ape in October of 2022. In January 2023, weeks after the December 22nd, 2022 announcement of the company's transaction with Antara and plan for a conversion vote, I made an additional large for him purchase of ape. And in the next docket entry, he cites the AK as an exhibit. And he's expecting the conversion to be completed by late March or early April, the latest, contemporaneously with the ape purchase in January. And then I purchased put options on AMC with expiration date April 21st, 2023. The size of the AMC put position acquired in January, as measured by the number of underlying shares, closely matched the number of additional ape shares I purchased in January, with APE expected to convert into common shares of AMC. The put options were purchased to protect the value of my stock investment against a possible decline in value shortly after the conversion. Long story short, I never knew what his stance was with regards to is he a good actor or a bad actor. I'm going to track this lawsuit, and I wanted to bring it to you guys' attention since I think most of you guys also own APE. So I am probably going to send a letter to the court inquiring if he completed or he complied with the judge's order to disseminate. Here, I'll show you once again on this docket entry. I think it's 7. So this is what the order was. It's regarding to notice to purported plaintiff class members. So the plaintiff filed a putative class action on behalf of persons or entities who purchased or otherwise acquired AMC preferred equity units between August 18th, 2022 and August 28th of 2023. And the complaint alleges violation of Section 10B of the Exchange Act of 1934. What the judge instructed that no later than November 20th, the plaintiff shall advise the court in writing of the date and manner in which it published this notice. And he didn't comply, so then she renewed the order on December 3rd, and I don't know if he complied with that. She gave him an extra 60 days to publish something to give us shareholders notice. Anyway, we got to thank this gentleman who brought it to my attention. So once again, I might submit a letter inquiring what's going on and seeing if he complied with either order number 7 or 8. Well, he definitely didn't comply with order number 7. Order number 8 is still outstanding, I'm thinking. Anyway, with that said, once again, I will publish the lawsuit so you can track it. You can go to pacermonitor.com. And in addition, this lawsuit I'll publish, and maybe in the next video we'll go over the allegations. I want to keep these videos short. Anyway, with that said, enjoy your Sunday, and that's it. Be good. Bye.